Okay, the next key thing for 2025 that we're going to look at is contract law. So page 89 in the notes. Notes are in the description beside this video. So if you're looking there, why should you learn this? Why is it important? Well, some element of contract law. So when we say some element of contract law, there's kind of three things to it, right? There's the essential elements of a contract. There's methods for terminating a contract, which is in big, bold, underlined writing there. I think that's the part that you need to be all over for this year in particular. Hasn't been asked since 2021 on the Leaving Cert proper, so we're not including the fair papers there. And then the other part of contract law is remedies for breach of contract. So one of those three at least has been assessed in 6 of the last 7 years. So it's just an essential part of Unit 1. So if we're trying to look at, from this thing that comes up nearly every year, which part of it's most likely, I do feel that the methods for terminating the contract are quite likely because you haven't seen it on the proper Leaving Cert to not the fair paper since 2021. So you could see any of these as a short question, or it could be question 1 or question 4, which in recent years have both been on Unit 1. So that's in part A of our long questions. So what do we need to know? You need to know the elements of a contract very well. You need to know them all. There's no cutting corners here, and you have to be very, very accurate with your explanations and definitions. Waffle won't cut it. It is keywords only to an extreme degree here. So you have to know what those relevant keywords examiner wants are. Make their job easy. You can get to the point with this stuff very quickly, and I'm going to show you a great exam script in a minute. From a student who was able to really quickly pick up marks, which is a great skill to have in Leaving Cert business. And then, yeah, know the methods for terminating a contract well. These are often asked alongside the elements of a contract. And for whatever reason, it tends to be the case that with contract questions, they often look for examples. So I would have them prepared, right? Just whilst we're on the examples, I'm going to show you a sample answer of a good example, bad example. One word examples, I'd always be sort of, a little bit wary of. Examples, the whole thing with your example is that it needs to illustrate your understanding, right? So you can see here, look, sample question, explain each of the following in relation to law of contract, providing an example. So here your second point of information is the example, but you can see they do look for an example. And so they could feed you the terms like this, so you can't leave any of them out, you can't cut any corners here. Just know all of them, right? Because you can get questions like this where they can cherry pick which elements of contract law they're going to ask you to explain. So if you just have a look at page 90 there for a second, and actually I want to show you the examples thing first of all. Let's say if you go to page 92, and let's say you're dealing with that question, right? And the question says, explain the following terms in relation to contract law, provide an example in each case, and you're given capacity, consideration, legality, and consent to contract. And there are 20 marks, 5 marks each. The 5 marks there, well, it's broken down 3 marks for an explanation with key words, so that key bit of info, theory or textbook knowledge, all the same thing, and then 2 marks for the example that crucially shows your understanding. So let's say you look at an answer here and someone's explaining capacity to contract, right? And this is what they write. So this is the element of a contract. So the element of a legal contract. Legal means the contract under law, so it can be brought to court if someone breaches it. That shows who can enter into a legal contract and who can't. For example, a 14-year-old. If I was to ask myself, if I was to look at that answer and ask myself, does that student understand what capacity to contract is? I would probably say, yeah, they do. They've got a good sense that capacity to contract is all about your ability in the eyes of a law to actually enter into a contract and for it to be seen as legally binding. But they just haven't used the correct language. So firstly, you haven't used the essential keywords, pick up marks for the explanation part, the explanation part. And the example doesn't show full understanding of why a 14-year-old doesn't have capacity. So even though they probably get a general gist of what it's all about, it's not picking them up marks. Compare that to answer 2 here, where this student says this is the legal power or ability of a person to enter into contract. That is perfect. That's exactly what we want to see. It's all about that wording, the legal ability to enter into contract. That's what capacity is about. Businesses acting ultra vires, bankrupt persons and diplomats would not have capacity. Example, a contract to buy a house is not legally binding if signed by a 14-year-old as they're not an adult. So it's really showing and understanding that they're a minor in the eyes of the law, so they don't have capacity. So just something to be conscious of, keywords and good examples that show understanding. With the essential elements of a contract, so if you look at page 90, there are 8 of them there, but I would treat it as 7, right? Because these first 2, offer and acceptance, they make up agreement. So if I was dealing with an exam question that asked me to outline or explain the elements of a valid contract, I wouldn't be relying on giving offer and acceptance as separate elements. I would put them under the umbrella of agreement, because the marking scheme has changed over the years on that. And like, I personally value consistency and certainty as much as possible when it comes to exams. So I would give agreement and explain offer and acceptance underneath that, and then move on to some of the other points, because like there's 7 of them there if we take that as one, right? So there's plenty of options for you. Because if you're looking at, like, this is an older question, explain the elements of a contract, you can see they're only taking agreement, they're not taking offer and acceptance separately. But on the next page, you'll see a question where they were taking offer, acceptance, and agreement. So I don't like that lack of certainty, so I would give agreement and explain offer and acceptance as part of that. Okay, so let's have a look at our keyword grid here. So remember, with the keyword grids, it's a good idea for you to try and replicate what is in this version in the student version on the next couple of pages, right? So it'd be a good idea now if you could, say, print out these pages. You can pause the video. It'd be amazing to have them in front of you, and you could write it out as we go along. You could pause the video and write them in as we go. Be a really, really good thing to do. Or you just take out a sheet of paper and again pause the video as we go. Or if you had a mini whiteboard, brilliant thing to do. Mini whiteboard, write it down, wipe it clean, rewrite it until the keywords and the key terms in your heading become second nature to you. So you should be trying to replicate the student version. So if you could just write out a little table like this, pause the video and do that. Same with these. At some stage, pause the video, watch this video, and try and replicate little grids like these, and then fill them out as we go through it. And then what you want to obviously do is get to a point where you can fill it out without looking at any notes or watching the video, right? So if we come up to the elements of a valid contract, what are our key words? What are we getting marks for? So these are the essential elements of a valid contract. So agreement, that's offer and acceptance. So for a contract to be valid, there must be an unconditional offer and acceptance of that offer. So that is the first thing that you could say. So that would be point 1. An offer can be made, and the same with accepted, can be offered or accepted orally, in writing, or by conduct. So you see that's the second point there. And crucially, an offer must be accepted without any conditions. If there are conditions attached, that's a counter offer. Example, just give any example of a transaction involving 2 people where the offer is accepted with no conditions. John offers to sell Mary his car for 5 grand. Mary accepts with no conditions. So simple example of any sort of offer and acceptance of that offer would be totally fine there. Consideration is the next one. So with consideration, 2 bits of info. So firstly, means that something of value must be exchanged. And a good second point to tag on is that it's usually money, but could also be goods. It's usually money, but could also be goods. So let's say that someone buys a phone for €280. The money and the phone are the consideration. Just a little tip there. It is good to hammer home the money and the phone are the consideration. Show your understanding. That's the idea here. So consideration, when you're explaining that something of value needs to be exchanged, it's usually money, could also be goods. For example, John buys a phone of Mary for 280 quid. The money and the phone are the consideration. Next element is legality of form. So some contracts must be in a particular format to be legal. So they must be in writing. Oral agreement would not work to buy a house. It has to be a written contract, is your example there. Capacity then, that's your legal power or legal ability to enter into a contract. Insane, bankrupt, business acting ultra vires, they don't have capacity. So with the examples for capacity, we explain it through a non-example, people who don't have capacity. So like we said earlier, 14-year-old doesn't have capacity because they're a minor. Consent to contract then, what's the key thing? Well, if someone's entering a contract, they have to be doing so voluntarily. So of their own free will, they cannot be forced or threatened to enter into contract. If they are, it's not valid in the eyes of the law. So if you're forced to enter into a contract at gunpoint, that is not considered legal. Next one, legality of purpose. A contract has to be for legal purposes or legal activities only. So it has to be for legal activities only to be considered a valid contract. Any other activities are not enforceable by law. So you can't take if you want to rob a bank and your getaway driver doesn't show up, that's not for a legal activity, so you can't take them to court. And then intention to contract. Last thing is, for a contract to be legally binding, parties must know that there are legal repercussions for breach of that contract. It is not just a social arrangement. So for a contract to be legally binding, both parties must know that there's legal repercussions for breaching that contract, and it's not just a social arrangement. So you can't sue someone for showing up or take them to court if they don't show up for a five-a-side match, because that's a social arrangement. There's no legal intention in that contract. So then, big asterisk beside the next one, the methods of terminating legal contracts. So let's be able to name them, explain them, and give examples. So the first one there is performance. So the first one is performance. So what is performance? Well, explaining it, it's where both parties fulfill their contractual obligations. So that should say contractual. So both parties fulfill their contractual obligations. We say, second point of information that you can use, the contract is executed as per the agreed terms. So it's executed as per the agreed terms. So in this case, both parties do what they're meant to do and the contract's done, right? So an example, a band is booked to perform a wedding. They perform and they get paid. Just one thing to be careful of with the example, you want to really hammer home that both parties perform their contractual obligations. So if you just say a band is booked to perform a wedding and they perform, you've shown one side have shown their fulfilled their contractual obligation, but the other side is they have to get paid. So you want to show that both parties do what they're meant to do. So a band are performed to play, they perform and they get paid. So everyone's done what they're meant to do. The next one then to look at is frustration. So in explaining that, crucial key word, a key term that you want to use is this is where an unforeseen event happens and it makes it impossible to complete the contract. So a good example there is death of a band member prevents them from performing a show or something like that. Next one then is agreement. So this is where a contract is ended by mutual consent. That'd be your first bit of info. Good second thing to tag on. Happens when neither party benefits from completion of the contract. So you could even put a little 1 and 2 beside these if you want. That's my first sentence, that's my second sentence. Really good example of agreement is a contract of employment can end if the employee gives the employer notice. So most contracts will say, if you give us 4 weeks heads up, and let us know that you intend to leave your job, we will agree to end the contract with that bit of notice. So that's agreement. It's mutual consent. And the last method for terminating a contract is breach. So this is where one side doesn't fulfill their contractual obligation. That wording is really, really good. It leaps off the page. You'll pick up marks for it. We say, second bit of info, that the contract has been repudiated. Really good thing to throw in there. So let's say that this is from a previous marketing scheme. Builder is hired to build a sunroom. They build a room with one window. They're in breach of contract. They have not fulfilled their contractual obligations, right? So if we come down and just look at some sample questions on this stuff. So we have some nice short questions here on page 96. You can pause this video, go and try them now. I'm going to jump straight to walking through the market scheme and the answers. So if we just look at this one in the middle, explain the legal term consideration and outline 2 other elements of a legally binding contract. See here, this is really typical of a short question. So even though the explain part of the definition of consideration is only one part of the question, they still make you work hard for the marks. So if you're looking, there was only 4 marks for that explanation, right? But of the 4 marks, it's broken down 2 and 2. So 2 marks for your first bit of info, 2 marks for your next bit of info. So this is particularly true of short questions. A lot of students will make the mistake in short questions. They under-answer the question. And like the fact that you're given limited space, it kind of is encouraging you to do that. So you need to get that skill of getting to the key thing quickly, because always with definitions and explanations, particularly with short questions, they'll always want 2 bits of keyword info, even if it's only 4 marks. So here with consideration, each party must exchange something of real value. So we mentioned that. And then remember, we said that thing earlier where it's usually in the form of money, but could also be something valuable. So it could be goods. So it's usually money, could be something else valuable. So 2 marks for something of real value, and 2 marks for a follow-up point. It's usually money, but could be something else valuable. Then the next part was just to outline 2 other elements of a legally binding contract. So state and explain 1 mark for stating, 2 marks for explaining. So you could say legality of purpose. So contract cannot be for something illegal. Legality of form. Certain contracts, or to be considered valid, they have to be in a particular form. So for example, they have to be in writing if you want to buy a house, for example. But I just want to have a quick look here at one on methods for terminating contract. Actually, you know what? I love this. Just to show you quickly, if you look at the bottom, page 99 there in the notes, that question that we looked at earlier, we looked at this question where you explain these terms in relation to contract law and give the example. If you look at this script from this student, look at how they've picked up full marks in 2 lines. So they just know exactly what the keywords are. There's no fluff. So they've got capacity, the legal power to enter the contract. Example, a director acting ultra vires has no capacity. Consideration, something of value. €1 for sweets in a shop. The sweets and the money are the consideration. Amazing. Like, they know the key terms. They just write it and they move on to the next thing. So really quickly picking up marks, like start to finish there. What are we? I don't know how many lines that is. Not many though. I'm guessing 12, 15 lines for a 20 marker, and they've got 20 out of 20. They've done very little work. They're leaving a line between each one. It's nicely laid out. They're flagging where they're dealing with the various terms. It is really, really good work. But I just want to look at this one here. So if you look at page 100, and let's have a little look at this question. So question is, read the info supplied and answer the questions which follow. So the band Stand and Deliver officially cancelled their upcoming tour date due to the death of their singer Richard Stairs. Explain the methods of terminating the legal contract referred to in the text. Part 2, outline 3 other methods for terminating a legal contract, providing an example in each case. So in this case, it was a 25 mark question. There was 4 marks going for part 1. So that 4 marks were broken down. 2 marks for stating the method, and then 2 marks for explaining. So 2 marks for saying frustration. Big thing you want to say there, it's an unforeseen event and makes it impossible for the contract to be completed. So unforeseen event and impossible, those 2 things go together. Then 3 other methods for terminating a contract. So state, breach, 2 marks, explain. One side does not perform their side of the contract. So they do not fulfill their contractual obligation. 3 marks for saying that, and then 2 marks for the example. Builders employed to build a conservatory or sunroom. They don't add any windows. We say the second party can take the builder to court there. Second party can take the builder to court. So 2 marks for that example. So like I mentioned earlier, they do tend to look for examples in these. So state, explain, example, agreement. Both parties agree by mutual consent to end the contract. So that's a key thing. It's all the examiner wants to see. Then an example, a contract of employment may be ended by agreement if it includes a clause stating that the contract will be terminated if a month's notice is given. So that's what I was saying earlier. 2 marks for that. Performance. Both parties carry out their duties, their contractual obligations. Easy marks. Know what the key thing is. A band is booked to perform a wedding. They perform as agreed and they get paid. So state, explain, example. Know what the key things are. Go and practice the questions.